Have you ever wondered whether you can sue for emotional distress after a frightening accident, even if you weren't physically hurt? In California, the answer is sometimes yes, but only under very specific conditions. This is known as a bystander claim for negligent infliction of emotional distress, or NIDE. This situation happens more often than people realize. Imagine you're driving your kids to school when another car runs a stop sign and crashes into you. No one is seriously injured, but you're terrified, not just for yourself, but especially for your child. Or picture standing on the sidewalk and watching a car slam into your child's school bus. Could you recover damages for the severe emotional trauma you experienced? The landmark California Supreme Court case that defines these rules is Thing versus Lechusa, decided in 1989. In that case, a mother arrived at the scene shortly after her child was injured in a car accident but did not actually witness the impact. The court used her situation to set clear limits on when a family member can sue for emotional distress after seeing harm to a loved one. Under the Thing test, to bring a successful bystander NIDE claim in California, you generally must prove three key things. First, you must be closely related to the injured person, typically a parent, child, spouse, or sibling. Second, you must have been present at the scene of the injury-producing event when it occurred and been aware that it was causing injury to your loved one. Simply arriving afterward and seeing the results is usually not enough. Third, as a result, you must have suffered serious emotional distress, something far beyond what an ordinary disinterested person would feel in the same situation. In California, the severity of the emotional distress is not just about damages, it is an essential element of the claim that must be proven. California law recognizes two main types of NIDE claims: direct victim claims and bystander claims. Family members who did not suffer physical injury almost always fall into the bystander category. And with very few exceptions, if you did not personally perceive the event causing the harm as it happened, recovery is difficult or impossible. The rules can get even more nuanced. Courts have debated exactly what it means to perceive the event, especially in cases involving medical negligence or defective products where the cause might not be immediately visible. The law in some of these grey areas is still developing. If you or a loved one has experienced a traumatic event and you're wondering whether you have a valid claim for negligent infliction of emotional distress, these cases are complex. The outcome often depends on the specific facts and timing of what you saw and experienced. Our personal injury lawyers have successfully litigated Thing cases throughout California. If you witness harm to a loved one, call Daniel Horowitz at 925-28-31863 to see if you qualify as an injured person under the current law. Again, that number is 925-283-1863.